Welcome to the Tony Love Show. My name is Antonio Love, and I'll be presenting a patent infringement case for you. This patent is 6,957,233, and it belongs to Microsoft at the moment. And they're using it to make Barnes & Noble pay up for the use of its technology in Android. So it all starts on the Microsoft On the Issues blog with a post by Horacio Gutierrez, a VP and Deputy General Counsel for Microsoft. And within the post, he says, this is only our 7th proactive patent infringement suit in our 36-year history. Yeah, but the problem is, you guys are losing, you guys didn't figure out your smartphone attack, and you guys still need to make money. So, whatever, about only the 7th. So this is occurring after a year of discussions, and Barnes & Noble just didn't want to accept their licensing terms and the program. It was filed March 21st, 2011 in the U.S. District Court for the Western District of Washington, which I think is Washington, D.C. I'm not sure. Now, what's under dispute is users want to annotate e-books and other documents, says their MS spokesperson, and as their position is, that means that they're using Microsoft technology for the Nook if users want to do this action. Now, in November of last year, Barnes & Noble filed a supplemental notice of prior art. Barnes & Noble was like, forget that, guys. That's out of here. You are misusing these patents, and they filed that claim as well, that Microsoft just wants to kill Android, that they're misusing these patents for that purpose, and they don't have full ownership over the patents. They had a 46-page document that had 100 examples of prior art technology that Microsoft really cites, saying that Microsoft doesn't have the ability to litigate. January 31st, though, Judge Theodore Essex of the ITC in the U.S. threw out this claim, unfortunately. Barnes & Noble didn't like the licensing program, the terms of the licensing program, and the fourth one is purchase of other patents, which is what Microsoft did in order to even be able to start this. In mid-February, Barnes & Noble kind of got some saving. I don't know, this guy, Jeff Sue, he's a staff attorney at ITC. I don't know what kind of clout he has, so I don't know how much saving really occurred there, and the judge doesn't have to follow his recommendation. So what is this patent? Let's see here what the details are. It's called Method and Apparatus for Capturing and Rendering Annotations for Non-Modifiable Electric Contents. Now, the abilities are selected objects, file position, and annotation are stored. This information is stored in a file which allows a separate file from the original file that you're reading, allowing for you to put annotations on something that can't be modified. This patent has 22 claims, but I only need to read one, and it is computer-implemented method of annotating a system, user-selectable objects, and annotations stored in non-modifiable portion of file. See, now there's a problem there. It says non-modifiable portion of file, but the technology is supposed to store information in a modified portion of either the documents file or another file. That seems like a typo there, so that's iffy. So yeah, Microsoft, their intentions. They're saying, hey, all these companies using using Android or using Microsoft technologies, we should be making money off of this, and they need to pay up. Some have, like HTC, they're the first one they went after, but Barnes & Noble won't. But I think Microsoft is finding a way to make money off of this because they can't hack it. They haven't come up with the innovation and the strategy to be able to compete against Android and Apple.